Calling case number 24-01173-SM. This is the people of the state of Michigan versus Len Derek Tyler Stringer. Mr. Angot, do you wish to place an appearance on the record?
Judge John Angot, I'm here as appointed counsel for Mr. Stringer regarding this arraignment. However, Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Len Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, it is charged by the people of the state of Michigan that in this city of Royal Oak, county of Oakland, and state of Michigan, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. If the victim is a minor, it is a Tier 2 offense. If you have a prior conviction for a Tier 1 offense, it is a Tier 3 offense. If you have a prior conviction for a Tier 2 offense. This is a high misdemeanor, punishable by up to 2 years in the state prison and up to $2,000. Also, a mandatory collection of DNA identifying profiling samples. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure. At this time, the court enters not guilty pleas on both of these matters, so that Mr. Stringer's presumption of innocence under the constitutions of Michigan.
The courtroom tension's already thick, but this moment says it all. Stringer's first move is denial of jurisdiction. He doesn't reject the charges. He rejects the court itself. Sovereign citizens often believe that unless they consent, laws can't apply to them. But that's not how reality or legal systems work. Notice how the judge doesn't even argue. That's experience at play. Judges have learned that debating a sovereign citizen is like arguing gravity. It's pointless. Instead, he calmly moves forward with the reading, preserving decorum and record accuracy. Question for you. Should courts even entertain these pseudo-legal claims, or should they cut them off immediately?
DSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference that will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today. If probable cause is either found or waived at that preliminary examination, the matter will be bound over to the Oakland County Circuit Court for further arraignment, trial, and proceedings. The court must now set bond in this matter, as it's not intended to prejudge or punish you. You are presumed innocent, Mr. Stringer. However, the court must set bond in order to ensure your reappearance to court and afford any necessary protection for the public. In that regard, the court would first hear from Detective Keith Baringa of the Royal Oak Police Department. Then the court would hear from your attorney, Mr. Stringer. Detective Baringa, please proceed.
Thank you. He currently has 2 warrants out of the state of Texas for assault and also in assault with injury to family violence out of Texas. He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying information.
Detective Binga's testimony changes the tone. This isn't a free-thinking philosopher. This is someone with 2 active warrants in Texas and a history of assault, weapons charges, and false ID use. The defense's earlier claim of business owner status now sounds like smoke and mirrors. The pool ban might sound oddly specific, but given the indecent exposure allegation, it's spot on. The court's balancing act here is key. Protect public safety while upholding Stringer's presumption of innocence. And yet, Stringer still believes this is all a paperwork illusion. A man detached from consequence, clinging to legal myths to avoid accountability.
Or government documents. I'm not sure if that's just like a generic false ID case or not, but multiple felons out of Texas. I'm not sure how long he's been in Michigan. He has no current cases out of Michigan that I'm aware of. His criminal history, he has assault from 2019 out of Hartford Woods, which looks like it was deferred as assaulting a public officer or obstructing, where he got served 9 days ago. And that is it out of Michigan.
Anything further?
So I would also ask that he not be allowed to return to any public or private pools in the city of Royal Oak or parks, grass areas adjacent to it. Or have that continue to.
Thank you very much. Mr. Angot.
Judge, as noted by the court, the presumption of innocence is absolute at this point. And so we must start from there. Mr. Stringer, or the person purporting to represent Mr. Stringer, is a business owner. Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court pretrial service.
Please, Mr. Stringer will appear for all his future dates as directed. He will abide any valid order or judgment entered in this case. Mr. Stringer, you will not leave the state of Michigan without permission of the court. Please don't commit any crimes while you're on release status. You will notify the court in writing of any change of address, telephone, or email. Mr. Stringer will be making reports to pretrial services, and they will supervise his release. There will be no use of alcohol, marijuana, or any other controlled substance without a valid prescription from a treating physician, and Mr. Stringer will abide a substance abuse testing and monitoring program. No purchase or possession of a firearm or other deadly weapon. Mr. Stringer shall not harass, intimidate, beat, wound, or threaten Linda Marino and Chad Stransky, nor will he cause, through himself or through any third party, to have direct or indirect contact with said individuals. Mr. Stringer will not enter the cities of Royal Oak or Berkeley except for court, work, or medical treatment. And at this time, there will be 2 ETGs per week for alcohol consumption and 3 controlled substance tests a month. Given everything that's before the court at this time, the court will set bond in the amount of $50,000, cash or surety, no 10% allowed at this time. If Mr. Stringer wishes to bring various motions before the examining judge, and that could include a motion to modify his bond, that is his right and his privilege, but at this time, that is the bond as set by this court.
Here's where irony meets justice. Stringer insists the person being charged isn't him, but the estate of Len Stringer. It's textbook sovereign citizen logic. Deny the entity, deny the crime. But think about it. If that logic worked, every criminal could walk free by declaring themselves a living being instead of a legal person. Courts have heard these arguments countless times, and every time they end the same way, with reality winning. Judge Angot remains composed, steering through the jargon like a ship through fog. It's patience versus delusion, and patience always prevails. What would you do if someone tried this defense in your courtroom?
3.
Good morning, Your Honor. Samira Malus on behalf of the people.
Good morning, Judge. For the record, David M. Sunutko appearing on behalf of Mr. Stringer.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Lynn Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
A living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. I have an individual before me that is listed as an Oakland County Jail inmate by the name of Len Stringer. I have a case that's been assigned to this court that where the defendant's name is Len Stringer. Mr. Sunutko, are you assigned on this case?
I am, Judge.
Okay, and you were assigned to the Stringer case, correct?
That's correct, Judge.
Okay, so that's enough for me to conduct this hearing today. Now let's walk through this. Miss Mount Lewis, have you provided discovery to Mr. Sunutko?
Your Honor, I didn't have an attorney listed. I believe if he filed, he may have just received written discovery. I didn't have that in my information, but give me 1 second to confirm. I'm just going to make one click.
In the meantime,
I do have written discovery, Judge.
So yeah, it sees that he was provided with written discovery on June 26th.
okay, so Mr. Sunutko, have you had a chance to talk to the defendant at all?
I did, Judge. I met with him at the Oakland County Jail
All right, and so
Tuesday.
So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call.
He next phase reveals what many sovereign citizen followers don't want you to see. Behind the pseudo-legal facade often lies a pattern of violence and instability. The record shows a man with years of assault charges and obstruction offenses, not a misunderstood activist. The judge's restraint here is remarkable. Instead of mocking Stringer, he orders a competency review, a necessary step when mental stability becomes a question. It's both humane and procedural. This case isn't just about law-breaking. It's about mental health, misinformation, and how internet conspiracy theories can erode someone's grasp of reality. Would you consider Stringer delusional or simply manipulative?
Plus, the way the defendant has presented today, that a competency review is in order, and so I'm happy to move forward with that. So, Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mount Lewis, can you prepare an order for competency review?
Yes, Your Honor.
All right. I agree. I think that that's appropriate at this time. I recognize that the defendant has made a request to have Mr. Sunutko removed from the case based on the information, though, that I've sort of observed at this time, as well as information received by Mr. Sunutko. I remain unconvinced that
defense attorneys.
What we're seeing here is a system doing exactly what it's designed to do: protect even those who reject it. The $50,000 bond, the restrictions, the testing, all calibrated to prevent harm and ensure appearance. But Stringer's reaction? Total disbelief. He treats accountability like oppression. That's the hallmark of the sovereign citizen mindset: freedom without responsibility. Yet the irony is perfect. His rights are safeguarded by the very structure he claims doesn't exist. The Constitution he dismisses is the only reason he's treated fairly at all. Let's hear from you. Do sovereign citizen defendants deserve extra patience, or should courts move faster to sanction these tactics?
Move Mr. Sunutko off the file. If I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What label, excuse me,
The evaluation, whether or not you can understand the nature of the proceedings at this time, that you have the ability.
I oversee the nature of the proceedings.
That you have the ability to assist your attorney in your defense.
To withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father, and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number, and he did not do that. So I would like him to withdraw from my case, sir. I have no. So he doesn't. He isn't.
I have a recommendation for pretrial services that suggests that there are untreated mental health concerns, and the nature of his criminal history and criminal contacts suggests that there may be significant mental health, untreated mental health issues. So, Mr. Stringer, I've heard your concern at this time. I'm not going to grant your request until I get a better idea of what your current mental health status is. So the request at this time is denied, but I will consider it again after an evaluation is done.
Hey, so who is the judge on my mental health? Because you can't obviously be a judge because, sir, I'm with my law, sir. So first off, I do not acknowledge myself to be Lindare.
You know, based on what I've seen, I disagree with your position right now, and we'll get you evaluated.
You cannot.
That's enough for now, and then we'll have you evaluated by the evaluated by the forensic center, and we'll go from there. Thank you, for Mr. Sunutko. Bond is continued.
Do we have a new date, Judge?
We'll set it 90 days.
And that wraps up the wild ride of Len Derek Tyler Stringer versus reality. What began as a simple arraignment turned into a crash course on sovereign citizen delusion, from rejecting identity to mistrusting counsel to questioning mental competence. Judge Angot and later judges handled it by the book, calm, professional, and unshaken. They protected Stringer's rights while maintaining control, a balance not every courtroom achieves. This case is a reminder that the law isn't just about punishment, it's about process. And even when defendants reject the system still protects them. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay curious, stay sharp, and keep watching justice unfold.